For hearing, item 1, WBC 3229/2020.
I think Lordship, the other side has already completed their submissions. So it is my turn now. Basically, what they have challenged.
So, we have, for the last section given the Lordship.
If we look at their prayer, Lordship, would kindly see page 10. So they are praying for a mandamus or certiorari to strike off serial number 11, private schools with 300 numbers of students to class 1 trade or profession as stated in the Annexure 1 of the 4th schedule of the Gauhati Municipal Corporation Act 1971, same as illegal, arbitrary, ultra-vires to the Constitution. Set aside the impugn notices, those are consequential order. But if they have basically challenged the provisions of the Act, with, more particularly, inclusion of private schools with 300 students in Schedule 4. And if we look at the writ petition, their whole thrust is on a judgment of the Supreme Court. PMA Pi Foundation versus State of Karnataka, reported in 2002, 8 SCC, page 481. These judgments they have relied, and also they are trying to say that providing education through private school is an occupation within the meaning of 19(1)(g) of the Constitution. And they have also referred to a case of 7 judges, P.A. Imandar versus State of Maharashtra, reported in 2005, 6 SCC, where education accepted, where the ratio laid down by Supreme Court, education accepted as a useful activity, whether for charity or for profit, is an occupation. Nevertheless, it does not cease to be a service to the society, even though an occupation, it cannot be equated to trade or a business. This Lordship will find in their synopsis. And I have gone through the writ petition. They have said that further, they have said that there is no rules under Article 1, under Section 180. So without the rules, we cannot implement or execute the provisions of Schedule 4. This is sum and substance their argument, and in the written argument, they have also said some additional points. I am just repeating all this because that will be easier for me to respond to all their arguments. So according to them, this provision which they have challenged is ultra-virus to the GMC Act, violative of the provisions of Article 14 and 19(1) of the Constitution. It's an arbitrary and colorable exercise of delegated legislative power. It lacks statutory authority. It imposes fees, compliance unrelated to regulation of education. It treats educational institution identical to commercial trading entity. Power under Article 19(6) of the Constitution of India is not available to the GMC. And they have elaborated and repeated the same things in their written argument. So my first submission would be, Lordship, I'll go to the details also. Article 19(1)(6), it is a fundamental right. What are the activities a person can do? Article, let us look at Article 19. How misconceived this writ petition is, I am trying to project. Right to freedom, that is the heading. 19 says, protection of certain rights regarding freedom of speech, etc. Sub-article 1 says, all citizens shall have the right to freedom of speech and expression, B, assemble peacefully and without arms, to form associations or unions, to move freely throughout the territory of India, to reside, settle in any part of the territory of India. F, it is no more there. Then G, to practice any profession or carry on any occupation, trade or business. So these are the rights which can be termed as fundamental rights granted under Chapter 3 of the Constitution of India to us, to the citizens of the country. So here there is no indication or no mandate or no discussion or no reasons to think that when we do any activity under Article 19, whether it is I give a speech or I express myself or I move around the country, I can form an association or union, or I can practice any profession or carry on any occupation or trade or business. This does not say that I don't have to pay fees, I don't have to buy tickets. Suppose I want to roam around the whole country. That is granted under 19(1)(d) to move freely throughout the territory of India. That does not mean that I can take any train without paying any ticket fee, or I can take a flight and go anywhere I can. What they are trying to say that as it has incorporated that the person can practice profession or carry on any occupation, trade or license, that means he can do it without any restriction. No, that is not the mandate. That is not the meaning of this article. So this I'll elaborate later on. This whole foundation of the writ petition on the basis of 19(1)(g) with the aid of EMA Pi and Imandar's case. Those are in some other context, and there is no question or issue that arose in those cases that whether education can be brought under the realm of taxation or under trade or license fee. These are not the issues. The issues are totally different. Minority institutions, who can take admission, what can be the government's control over those institutions. Those are the issues. What is a valid degree? I will place those two judgments also. So those two judgments have nothing to do with the Gauhati municipal.
Perhaps they are challenging that your class 1 of the 4th schedule, on the count that you are discriminating, you are leaving different kinds of fees for those schools and colleges, those schools who have 300 and plus students.
That I could not find out in the writ petition, and neither in their written arguments. I'm sorry, I was not present when the verbal argument was made, but the notings which my colleagues have noted, this was not their argument.
Okay.
If that be the discretion, then there should be a violation of Article 14. Then my whole argument will be different. Now whatever they have pleaded, I am making my argument on the basis of their ground and
in the prayer also it says, direction should not be issued at page 10. Striking off and quashing off serial number 11, private schools above 300 numbers of students to be class 1 trade profession.
If that be the case, then we can also amend it, then all private schools, irrespective of number of students. There is a reasonable justification why 300 has been taken. If that be the case, then we have to file an additional affidavit to that effect. Why 300 and not 250, not 100, not 50 students? If that be the case, Lordship, then factually I have to make some additional paragraph in my additional affidavit. If that be the case.
Yes, Mr. Roy.
My lord, yes. Your Lordship, the 4th schedule, the incorporation they made, your Lordship is right. My lord, it says trade 47. In our written argument also we have categorically said, my lord, said this. There is a discrimination of 306 students. That your Lordship will find. Lordship is right, my lord. And we have challenged the very entry made, my lord. The very provision in the prayer also.
What was the legislative intention of making a particular category of private schools above 300?
Get to the text only. Just a moment. Where is that GMC Act?
And subsequent notification says below 20.
Good. Where is that schedule?
That schedule is at page 194, if Rosim is taking the same book.
94.
Schedule starts at 104, schedule starts at 184, and annexer 1 is at 194.
And what is the entry number?
Entry number, Lordship, it is 11.
11. Private
11.
schools above 300 numbers of students. Okay.
At 47, advocate chamber is there, Lordship.
It should be transmitted. And this is the user.
If they are pursuing that argument, Lordship, then Lordship will kindly grant me time to file a additional affidavit to counter that. But that was not their pleaded case, so our affidavit have no response to this ground of discrimination.
This annexure 1, this serial number 11, it came when?
It came in 2018, sir. I'm just
2018.
2009.
2009.
And there's the revision of the fees also, along with that.
किसी text to लगा दिया है ना, किसी text to लगा दिया है.
My lord, this amendment is not brought on record, my lord. This 2009, they are saying, by way of what? There is no notification, my lord.
So now these grounds are being asked without actually putting them in the petition.
We have said, my lord, there is no
In the
law.
if verbal argument on factual point is not permissible. The notification, and then I'll have to, that has to be pleaded first, that there was no notification. So I'm getting one after another googly lordship here. Then just look. Seven, eight.
Yes,
Yeah.
Para 9 you said.
The notification date we have in another case, we have referred to it. 1st June 2009. It was brought. PMA file.
Para 9 is not replied, my lord.
No, no.
এটা ঠিক আছে, 44 হচ্ছে।
What they have said, even Gauhati Municipal Government in the year 94, 2003, 12, 19 and 20 did not make any amendment incorporating private schools and educational institutions as trade. But surprisingly, in the new publication of the Gauhati Municipal Act 1971 provides for an annexure in the fourth schedule with heading trades to be included in class 1 with serial number 11 at so and so. So they want a separate notification to include schools as trade. This is the plain meaning of the sentence. How can they?
And
Without
section
that amendment, how this is-
184 provides that power.
Amendment from board. The meaning of that sentence is that we have to incorporate that under trade. But what we have done is that we have given the whole annexure, the amendment. We don't have to give everyday trade under the meaning of trade. We have given an annexure, whole annexure, and one part of the annexure is put to challenge. Whether we have that power to insert that amendment or not.
Without the act being amended.
This is a part of the act. Section 180. Lordship will kindly say section 180.
No, that's not there. They are trying to say that originally this was not included. So
Because
therefore, when you are amending annexure A, that also requires amendment of the parent act.
parent act, let us see section 180.
As amended then, madam.
Section 180, license to be taken out annually. Every person who exercises or carries in the city either by himself or by an agent or representative any of the professions, trade and callings indicated in the fourth schedule. So now this fourth schedule I am placing. Lordship will kindly now come to page 184, fourth schedule under 180. See section 180, fourth schedule below that. That is the sentence language and wording. Every license shall be granted under one or other of the classes mentioned in the second column of the following trade, and there shall be paid annually in the same of the fees mentioned in behalf of the third column of the trade. So here, this is the whole chart, and there itself, the annexer trade to be included in class 1 category are included in this. Example, drug dealer for placement. It's like on the flag. Government একটু দেখতে হবে। হুম? হুম? কেন? GDP দোপা কেটে বলে Lordship, I have a different submission to make. I have just verified. I just wanted to see whether government has filed the affidavit or not in this case. If Lordship is pleased to come to page 3, because municipal corporation and the commissioner cannot defend the challenge. The state of Assam, respondent number 1. The state of Assam representative commissioner secretary, Gauhati Development Department. That department, Lordship, is no more in existence from 2021 July. And prior to that, this about 7-8 months prior that, this department was becoming dysfunctional and it was abolished. So a affidavit of the state government may be required. In fact, in my humble submission, it is most crucial because the challenge of the state government's legislation is the subject matter here. Because the municipal corporation or the commissioner are not the authorities to defend this case, so far as the challenge is about the ultra virus and unconstitutionality of the provision. And that affidavit, and because the department is no more in existence, in fact, at that point, we are not in GMC also when this first affidavit was filed. First time I paid for some. Hmm? Hmm?
Yes, sir. Original is here. Original is here. Which we see now. Which one now? Take it from the hand. License is not like that. Take it from the permission कोई बोलेगा डिपार्टमेंट की सॉफ्टवेयर कोई बोलेगा कमिश्नर से गवर्नमेंट ऑफ असम गुवाहाटी म्युनिसिपल जो गवर्नमेंट है सही क्या
Lordship.
this would be secretary to the government of Assam municipal administration department.
No, Lordship. Originally, it was, there are two departments. In 1994, Gauhati Development Department was there, and Urban Development Department in 2002, there are two parallel departments. Both were merged in 2022, July 20th. On that day, a new department has been formed, Department of Housing and Urban Affairs. So that is the department. Now, with the merger of GDD and UDD. And all the legislative actions are done by the department, not by the corporation.
Okay, so it will be housing and urban department.
It will be Department of House, DOHUA, Department of Housing and Urban Affairs, Government of Assam.
All the municipalities come within that.
Yeah, exactly.
Okay.
They have to amend the petition.
The earlier that municipal administration department was there. It's no longer.
MAD, it is no more in existence.
Okay.
From July 2021. To secretary, no? Secretary or the commissioner secretary. Kalpana is Kavita ki naam tha na? Kavita Padmanavan asle adi long 7-8 years, 5 years ma. The tai jaga notun ke tumbai se. Recent. July 22 July 2021. 20th July 20.
But Mr. P.K. Roy, learned senior counsel, assisted by Mr. J. Sinha, learned counsel for the petitioner. Also heard Mr. D. Saikia, learned advocate general for the state, assisted by Mr. B. Gogoi, learned standing also for the respondent numbers 2 and 3.
He will be, till now, S1 number is not correct. So they have to amend the petition.
No, 2 and 3 is right.
2 and 3 is Shantanu Bora, S. Bora.
Mr. S. Bora. which has border is standing counsel for the respondents 2 and 3. Next para. While responding to the submissions made by the learned senior counsel for the petitioner, that one of his grounds to assail the insertion of serial number 11 in annexure 1 of class 1 of schedule 4 of the Gauhati Municipal Corporation Act is that there was no corresponding amendment to the act, the learned Advocate General has submitted that the appropriate authority to respond to that submission would be the Department of Housing and Urban Affairs from a Government of Assam. It is submitted that the respondent number 1 was read through the Gauhati Development Department, which is no more in existence. Next one. In view of the said submissions made by the learned Advocate General for the state, the court is inclined to direct the implementation of the Department of Housing and Urban Affairs by Government of Assam by substitution of the Gauhati Development Department, to which the state of Assam was arrayed as respondent number 1. Next para. Accordingly, the registry shall make the following corrections in the corrections of the amendment to the cost title in respect of respondent number 1, which shall now be read as start inverted commas in next para. The state of Assam, represented by the
Principal
Secretary
Secretary
to the Government of Assam, Department of Housing and Urban Affairs, Dispur, Guwahati 781006. Full stop. The next para, the necessary corrections shall be made by the registry, and next para, as paid for by the learned Advocate General. How much time?
4 weeks time may begin.
Can we make it 3? Because this is spending
No
a quite
difficult.
long time.
No difficult. Only because of the flood, people are all moving around. That's why I was asking.
Okay. The placement is granted 4 weeks time to file an affidavit in opposition in the matter. Next para. The affidavit shall be filed at least 2 days prior to the next date of listing. Next para. List on, give a date after 4 weeks.
2nd or 3rd of September, Lord. 2nd will be with, 3rd will be Thursday.
Can it be after third?
The matter may be next listed on 3/9/2026. Subject to
Can it be prior to third or after 5th, Lord? After 5th, I will be here.
That's 8th of September.
8th of September.
8th of September.
8th of September. The listing will be subject to availability of the bench at the principal seat.
Highly obliged.
Because if the bench is not available here, then it's very difficult to have it
And if we
online.
don't file this affidavit, that will be a major shortfall from our part. Because
No,
we
it's
have-
okay, we accept your statement.
So, come on.
Just 1 minute. I mean, I was prepared to do the case. In fact, whole morning I spent on this case today. That also did not click me. And the pleadings were not very clear. They were using the word publication. Had it been amendment, the things would have been different. They have used the word publication. I may appeal.
In item number 2, Miller, petitioner already died, and yesterday I filed Miller one IA for implement of the family member. In item 2, yesterday filed Miller.
Learned counsel for the petitioner has submitted that the petitioner has expired, and yesterday an interrogatory application has been filed for including of the legal representatives of the deceased petitioner. Next paragraph, the matter stands adjourned today. Let the said interrogatory application list this matter along with the said interrogatory application. Okay.
Published.
May I please, my lord, in item number 9 and 11, my lord, kindly allow me to see the PCRE. Most of it.
My lordship, I beg to mention item number 6, my lordship. Here the engaged counsel NI Majarway is out of station. With the health checkup, my lordship. I could not able to locate the file, my lordship, in his chamber. Yesterday I have also gone, today morning also I have gone, my lordship. Kindly it may be taken on Monday, my lordship. It's coming on Saturday. I tried to contact him, my lordship, but unable to.
Item 6 on the prayer made by both sides are present or the prayer made by counsel of the petitioner. List on. Make it Monday. Okay.
Deeply obliged.
Supplementary item 19 for motion.
May I please, my lord, we pray to withdraw this petition, my lord, with liberty to file a fresh, my lord. We pray to withdraw, my lord, with liberty to file a fresh, my lord.
You have to tell us reason why you want to withdraw. Because this is 2025 matter. After a year, you are trying to withdraw. So this is actually on the prayer made by Mr. Both sides are presented. on the prayer made by Mr. K.M. Hasan and counsel for the petitioner, the matter can dismiss on withdrawal with liberty to file again. Can you just show the names and respondents? Show the source code. Okay.
Daily list item 1 for admission.
May I plead your lordship? Lordship, petitioner declares the foreigner minor judgment and order dated 29 my lord, page number 22 my lord.
Yes, we're challenging
Page 23 is order my lord.
The challenging 2019 order, you have to address us on the issue of delay latches.
My lord, in this case, my lord, petitioner own brother, my lord, declare as a non-foreigner, my lord. I have added this order, my lord.
No, but why the delay?
Delay, my lord.
Where is your written statement?
I am not MX here, my lord.
Yes, please continue.
My lord.
Yes,
My lord.
yes. Make your submissions.
Yes, my lord. The petitioner grandfather's name is recorded in this voter list 1966 and 70 also, my lord. I have annex here, my lord, annexure 1 and 2, page number 13, my lord. Again, my lord, petitioner's fathers, along with his family members' name is recorded in this voter list 1997, my lord. Page annexure 4, page 19, my lord. I have annexed also another, my lord, the school certificate also, page number 21, my lord. He read up to class 3, my lord. Here, my lord, mentioned his date of birth is 15/6/1980, my lord. Page 22, my lord.
Please continue. We are hearing you.
My lord, my lord, same documents, annex petitioner brothers, my lord, he has declared as a non-veranous, my lord. That order, my lord, I have annex, my lord, annexure 9, page 34 also, my lord. Same grandfather's documents, same petitioner's father's documents, annex, my lord, he is also, my lord.
Which page?
My lord, page 34.
Thirty-two. Any voters list, you along with your brothers or your parents and all your brothers together?
No, my lord. Only grandfather's, my lord. Uh, Yes, my lord. Page 17, my lord. Page 17, annexure 3, my lord. Serial number 3 is his brother, my lord, Bakhtar Ali Sheikh, my lord.
moved the matter, you did not refer to that earlier, the other opinion of your brother. You could have filed both the records together. This, both is the representative, this advisor and counsel for the petitioner has referred to hearing dated 6/2/2017, passed by the learned member from Foreigners Tribunal 10th, Dhubri, Assam, page 34. And so and so and so. And it is projected that the brother of the petitioner was declared not to be a foreigner. Next, accordingly, court is inclined to call for the record of the case taking over. By being email to the following email address. This is daily to the earlier on 29/10/2025. Next one. List of so and so awaiting receipt of the records. Before that summary, right, will be pursuant to order fast tracking, the record of the trouble is received. Okay.
Obligation.
For admission, supplementary item 20. August 28. August. For hearing, item 3. Item 4.
Wait, Mr. Lordship. Lordship, can we pass forward this matter for time being?
Item 5.
Wait, please, Lordship. Lordship, kindly call for timing. Lordship. Lordship.
Item 7.
Negligence. The petitioner's father name appeared in the voter list of 1971, parents' name, page 16, 16. Hamsul Haq, the father, and Salema Khatun, the mother. And thereafter, it is exhibit 1. And page 97, voter list, page 80. Page 19, name of the family members. Hamsul Haq, Salema Khatun, Sanatullah, Mizanur Rahman. Brother Mizanur Rahman is the father, and Mizanur Rahman is evidence as DW2. 19, 1. Voter list of 1997. Father, mother, elongated brothers. Mizanur Rahman is the brother, and Mizanur Rahman reduced evidence as DW2. In the WS, subsequently WS space, we start from 47. And 37 WS. And 55 you will also tell 55. You will also go to 55. Serial number 31. The opposite party has 5 brothers, namely Solomon, Mizanur. It is mentioned 55, 31 in the WS. Siblings name mentioned 5 brothers, Solomon, Mizanur Rahman, and Mizanur Rahman adduces evidence as DW2, page 65. We'll also go to 7. And the other sheet, and into judgment, page 83. That's it. Relevant person, page 86. Middle portion, paragraph 5. It is noted that, in the
it is noted that in his written statement, OP is silent regarding his brothers and sisters, regarding the sisters of the same religion. In public mention, but in the judgment it is not mentioned. Which information are within his special knowledge? The written statement is a basic defense. As his citizenship is questioned by the state, he has not disclosed relevant facts such as a question of our citizenship. In the WS it is mentioned what does mean. And father's name in the 1971. Though 66 total list, grandmother's name is there, but it is not exhibited. I have to annex in the page 13. But in 71 total list, father's name is there, father, mother. And 97 total is exhibit 2, parents with brother Mizanur Rahman, name is there, other person. And Mizanur Rahman, it is evidence, and GW2. But before her name recorded in the voter list, she was married in 85, and her name appeared in the voter list with husband. That's it, they're not but after 85.
My lord. I find this not your lordship. So I can take the help of the record lordship.
The LCR. You want the LCR?
Some wrong file has come lord. Yes, sir.
After 1985 petitioner's name is Mr.
Husband. I have annexed it. It is page 24 onwards, 85, 97, 2006. And in this case, Exhibit 5, it is Ward Commissioner has issued certificate in favor of the petitioner, page 33. Corporate Mutual Board, Ward Commissioner, Jamina Khatun, daughter of Consul Haq. That Jamina Khatun is married with Abdul Khaled, son of Consul of Nisuka, Postway Korpato. And this Ward Commissioner and there is Gambura certificate also there, is page 34. Is the particular. Gambura Nisuka, husband. Nisuka. Jamina Khatun, wife, so. And the Gambura was examined your lordship as DW4. In this case, your lordship, all the details are crossed by the residing officer activity is not by the member of the tribunal. But it's not. The evidence it is not permissible. That's it.
1997, your name appears in 19.
What's the link here? 1971 voter list, parents voter is there. In 97 voter list, parents with brother. Brother's name is there. And brother evidence is given.
Petitioner's name, you not have the petitioner's name in the
with the husband is there, but there is no in the family member. With the father's father is not there. Like already married to it. That's why linked. And member says he is not disclosed his brother's name. And how the brother has come and it is evidence. But already the other name is there with the father and brother name in the tablets also she mentioned. That's the linkage there.
The linking document is the what commissioner and council.
Like a Gambura certificate. Yes, land document is also there, but in favor of his father. Jamabandu copy and annex, it is exhibited, exhibit 4, Jamabandu, but in favor of the father, nothing else. Yes. The linkage only Gangwala circuit, Milcher Road and brother is also. Already father, mother expired, so brother is there, brother it is there. Page 87 of a judgment. Page 87, page 87 attachment. It is 4. Paragraph 4 from bottom. OP has examined 87 of it. They will believe the evidence of DW2 Dinadro. From bottom, paragraph 4, OP has examined one Mizanur Rahman as her witness DW2, who has identified himself as OP's brother. Whereas OP has never stated that she is the brother of named Mizanur Rahman. That's what is displayed. So on this, it appears in evidence he stated brother, and the Gauhati is also stated. In this case, OP examined as DW1, her brother Mizanur Rahman evidence DW2, and evidence of husband is not relevant because husband is 3, and Gambra examined as DW4. All the DWs are examined, cross-examined by the member of. Lordship. But
Your brother's name is in the industry.
yes, page 55, 40, except from 47 and 55. Serial number 31. The OP is examined, the OP's second party has 5 brothers, Solomon Ali, Bilal Hussain, Mizanur Rahman, 8 is different, in Islam and Dilwar Hussain, and 4 sisters. It is mentioned, but the only, it is not mentioned.
Lordship. Yes. There is no link at all object. Otherwise, Lordship, there may be some infirmity, Lordship, in the opinion, but Lordship, if we see the record of the resolution, then I find, Lordship, there is no link at all with this project and procedure, Lordship. Yes. Yes, yes, Lordship. Yes. Passport.
Thank you. Yes, 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 39.
We have been deliberating. It's not the issue as to whether the tribunal has been able to prove, the petitioner has been able to prove anything from the tribunal. So it is for the tribunal to take a call and then appreciate that evidence of the brother, and then give a finding whether it is admissible or not. It can arrive at the same finding again, that the documents do not prove anything. But so far as the order is concerned, it is perverse because of the fact that there on two occasions in the written statement, the name of the brothers are given. So I could understand if one is missed out, but if the tribunal is missing out twice, that means there is no application of mine. You have seen the written statement
Yes, Lordship, in written statement, he has mentioned
twice.
Yes, Lordship. But Lordship, what the evidence in brother has
It
done
is
that,
arrived at the same finding.
yes, Lordship.
The question is that the secondary art jurisdiction is only to see if it is perverse,
Yes,
not to find out whether, despite perversity,
Lord,
whether the finding would be same or not.
Yes.
That would be reappreciation of the evidence,
yes, please.
which we may not like to do. And we are also asking you to make your submission on this certified copy of the Jamabandi. What do you say, whether Jamabandi has to be, original record has to be called for according to you, or the certified copy of Jamabandi falls within the meaning of section 74 of the Evidence Act, and presumption of which can be taken under section 79.
Lord.
See, we'll tell you what is there. Take this. See, the 41. B.
Lordship, please.
41B, I think 25 from that.
Section 41B.
Page 18. 41. So entries in the record and the effect.
Entries in record and their effect. Entries in the records made under section 40 shall be founded on the basis of actual possession, and all disputes regarding such entries whether taken up by the settlement officer of his own motion or on the application of the party concerned shall be investigated and decided by him on that basis, and all persons not in possession but claiming the right to be so shall be referred by him
So the
to the
proper
court.
2.
Yes, every entry and record of right made under this section, under This section shall until the contrary is proved, be presumed to be true. Correct.
Correct. 41(2) says it should be presumed to be correct. Now certified copy is made. It depends on your submission, that whether you would like the, the corrector to always send their representatives to prove the document.
It is my lord certified copy, then it is,
But then it will come under section 74 of the Evidence Act.
yes, okay.
74 says of the Evidence Act. It plus. I'm referring to this Evidence Act because I'm more familiar than the BNS.
Yes, okay. Public document, the following documents are public documents, documents for
Yes.
forming the act.
74(3) of public officers, they issue the judicial and executive in India.
Yeah.
Or of a
On
foreign
public
country.
and
So this
legislative.
falls within that. Now, certified copy of public document is there will be 79.
Presumption as to genuineness of certificate.
Certified copy.
The court shall presume every document purporting to be a certificate, certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer of the central government or state government or by any officer in the state of Jammu and Kashmir who is duly authorized thereto by the central government.
Now 75, come to 75 now.
Private document.
There will be 74 certified copies of public document. Is it right? 74.
Yes, doctor.
Ah.
The following documents are public documents. The documents forming the act or records of act of the sovereign authority of
And what is 75?
75 private document received
And then
Then
26.
76 certified copies of public documents. Every public officer having the custody of a public document who is any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees. Therefore, together with a certificate.
That means certified copy can be issued.
Yes, yes, sir.
Then next section.
Proof of documents by production of certified copies. Such certified copies may be produced in proof of the contents of the public documents or parts of public documents of which they purport to be copies.
Correct.
Yes, sir.
Therefore, it can be made. Now, those certified copies can otherwise be proved.
Yes.
Now, for the purposes of this issue, you can make a convincing argument that the original records are required to be called for. Or if there is any earlier pronouncement of this court where it has been held that the entries in the revenue record has to be proved by calling for the audit. Then otherwise we don't find there is any necessity to call for the settlement officers or the representative of the office of the collector to prove the Gauhati.
Yes, Lordship. Here, Lordship, in this case, Lordship, we are only to see the link, whether person concerned can.
This is a finding of the tribunal.
Yes, yes.
Look at the finding. Finding says that the document is discarded because original was not found. You find it out. If you have the record.
Yes, yes. Excessive data.
This page 86, last paragraph.
Certified copy of Jomabandi is not proved by the custodian of the original record. As per law of evidence, documentary evidence has to be proved on the basis of record. Not only the document has to be proved, but its contents also.
Family is fundamentally wrong. Unless you show that in connection with these foreigners cases, there are pronouncements of this court which have declared so.
Also.
Can Frankie tell us at 2 o'clock if there is any other pronouncement, we will take up other after 1 or 2 days.
Lots.
You can show us any pronouncement where
In respect of
matching
Jomabandi.
the records,
In respect of Jomabandi or revenue record.
any revenue record. It will cover a wide spectrum.
Otherwise, lordship may day after tomorrow, Thursday.
That is the only point.
Lordship.
But that will be. This. Parliament events inclusive. It's a teacher, in bottom line. Praise for a day's time to find out as to whether there is any judicial pronouncement in foreigners matters that the land revenue records are required to be proved by calling for the original records. That's all. Nice from. Yeah.
In my lord Nur Begum's case, some lines have been quoted, lordship. I will further make my submission, lordship, on day after tomorrow. But what in this case, the court has stated the document brought on record for the purpose of establishing linkage to Rajan Ali is the Jamabandi at Exhibit 7, which, however, did not stand proof by means of related sale deed. Besides, there is no order of mutation saying that the name of the petitioner having inherited in the land. The Jamabandi document thus has no relevance.
Nur Begum.
Nur Begum,
And
lordship.
you are.
NUR, it is reported in respect of oral evidence. We are submitting this lordship 2023 GLT 347. T 20203 GLT 347. Okay. In NUR, Nur Begum. PEGU.
2023 GLT 347.
Yes, lordship. Versus Union of India lordship, and connected WPC is 1900 of 2019. Okay. Day after tomorrow, I will make my submission. Okay.
So this one is started on a different ground.
Different.
It says there's no order showing.
Petitioner
name of the petitioner.
Yeah,
The
different.
document does have no relevance as it does not serve the link to link the petitioner with the projected father. Because in this case, there was no voters list. Her name did not enter in the voters list for till her age of 50 years. Yet the projected grandmother was the voter at the age of 60 years without grandfather.
For hearing, time being item 5.
Yes, right.
Maybe. My lord, in this petition, my lord, basically, my lord, two grounds, my lord, we have are. Lordship kindly see at page, my lord, 20 and 23, the very first point, my lord. We have also in the last occasion, my lord, gone through the, my lord, records, my lord. Page 20, my lord, first, my lord. Paragraph 19, remarks of the inquiry officer. During inquiry in a prima facie manner, it appears to me that the suspect and the so and so is not IM. That is, my lord, is not illegal migrant. Is informed by his local police by so and so, so and so, so and so. So basically, my lord, there is no reference. And page 23, Lordship kindly see in the reference, my lord, page 23. That is agree with the, my lord, inquiry report, my lord. Inquiry officer's final finding. During inquiry in a prima facie manner, it appears to me that suspect so and so, so and so, so and so is not IM. That is not illegal, not a illegal migrant. He is informed by his local police, Bhagwan, white number so and so, so and so. Hence, the case is forwarded to the Honorable FT Court, Kamrup M. 3 for kind perusal of the opinion. That is the reference. And original lordship will find at page 26. এইটুকু reference, original, page 26, এইটুকু, deputy commissioner, page 26. Commissioner and Gauhati. This is reference. Reference lordship original at page 26. Yes, page 26, madam. Yes, this is the reference, madam. It says, madam, may I read, madam? The inquiry officer's final finding. During inquiry in a prima facie manner, it appears to me that the suspect MD so and so is not illegal migrant, as informed by his local police station so and so. Now, below lordship will find the signatory is not the Deputy Commissioner of Police, M. Gauhati.
What proceed? What case was forwarded to Promotional Tribunal Lordship? Yes, this is Inspector Border, but not SP Lordship. Then SP forwarded the matter to the yes,
Yes, 26, sir. Yes, 26.
Peruse and supervise the case records and verification of documents agrees with the opinion of inquiry officer's report. Hence, the case is forwarded to the Honorable Member SPK Metro 3 for opinion. Inspector Border, Inspector Border Gauhati. So, Lordship, but why DCB Border forwarded the case to what Lordship? Yes, Lordship. Yes. Lordship, regarding that, Lordship, I want to submit few lines from Aziz Mia's case, Lordship, 2023, 4 GLT 246. 2023, 4 GLT. 246. Yes, Lordship. What is name? Aziz Mia, AZIZ MIYA, alias Muhammad Aziz Mia, AZIZ Mia, WPC 2370 2023. Decided on 9/6/2023. May I read this, my lord? The petitioner Aziz Mia was referred to the Foreigners Tribunal number 2, Kamrup Metro for rendering an opinion
as to whether he is a foreigner as defined in the Foreigners Act 1946, who entered the state of Assam from the specified territory, resulting in registration of FT case number 165 of 2015 corresponding to IMDT case number 239 of 2001. In the proceeding before the tribunal, the petitioner made an application with a prayer that the proceeding itself be dropped in as much as the enquiring authority in its report submitted that during the inquiry, the petitioner could produce a voter list of 1966 which belonged to his fathers to prove that he is not a foreigner, and accordingly the inquiring authority had given a view that the petitioner is not an illegal migrant. But in spite of such report by inquiring authority, the Superintendent of Police Border Kamrup made a reference to the Foreigners Tribunal, resulting in registration of the aforesaid FT case number 165 of 2015. By the order dated 23/2023, the tribunal was of the view that as the referral authority had suspected the petitioner to be an illegal migrant of post 71, the prayer to drop the proceeding against the petitioner cannot be accepted. Being aggrieved, this writ petition is instituted. Then Lordship para 4, Mr. R. Learned Counsel for the petitioner submits that under the paragraph number 97 of the judgment of the full bench of this court in the state of Assam and others versus Muslim Mandal and others reported in 2013 1 GLT 809, there is a requirement under the law that before making a reference, an inquiry should also be conducted by the authorities, giving an opportunity to the suspected person to prove before the authority itself that he is not a foreigner. By taking recourse of paragraph 97 of Muslim Mandal, it is the submission of Mr. R. Ali, Learned Counsel for the petitioner, that as in the instant case, the petitioner succeeded in proving before the inquiring authority that he is not a foreigner, and therefore the subsequent reference by the Superintendent of Police Border to the Foreigners Tribunal is a defective reference, and further, as the reference itself is defective, no jurisdiction is vested upon the tribunal to proceed against the petitioner. Accordingly, it is the submission that the conclusion arrived at the tribunal in order impugn dated 23/2023 is unsustainable in law. To substantiate this submission, the petitioner relies upon the earlier judgment rendered by the division bench in WBC number 2674 of 2016, Monwara Khatun versus Union of India and others. By referring to said judgment of the division bench, it is the submission of Mr. R. Ali, Learned Counsel for the petitioner, that as the reference made by the Superintendent of Police Border Kamrup was defective, therefore there is a requirement under the law to return the reference back to the Superintendent of Police Border Kamrup, and in the circumstances, the reference before the tribunal would not be maintainable any further. Ms. A. Burma, Learned Counsel for the Home Department of the Government of Assam, submits that the provisions of paragraph 97 of the judgment of full bench of this court rendered in Muslim Mandal is only for the purpose of giving an opportunity to the suspected person to prove that he is a citizen, and such provision had been incorporated in paragraph 97 of the judgment of Muslim Mandal pursuant to the provisions of Article 21 of the Constitution of India, and that the role of the inquiring authority is merely to give an opportunity to the suspected person, and the inquiring authority is not vested with any power to arrive at a final conclusion as to whether the suspected person who was inquired is a foreigner or is not a foreigner. In these circumstances, one of the issues for determination before the court would be whether the report of the inquiring authority made pursuant to the provisions of paragraph 97 of the Muslim Mandal would be a final decision as to whether the suspected person is a foreigner or not, or the report is merely indicative in nature, which would require the Superintendent of Police Border to make a reference to the tribunal to render an opinion as to whether the suspected person is a foreigner or not. So then para 8, the entire argument of Current was based only on the fixed working English WP message dot was stated dot Question बराबर आता है कि मोहम्मद इब्न अली village Munhar Pittsburgh found child also consulted is available yes paper but found nothing independent of paper payment in support of his methodology he submitted on NRC legacy data for of his grandfather named Hanif Uddin. After the lawsuit in 1961 totally and of village Ramhui Rosiko after that 2017 totally lawsuit. These are next lawsuit I have remarked lawsuit on the basis of this lawsuit. Date of 29/1/2017. And lawsuit may in during inquiry were I know have submitted lawsuit on the সেই সূচনার পৰা অহা WT মেছেজ মৰ্মে জনা যায় যে তেওঁলোকে ধৰ ফোনটো Their WT message was followed by this city police lawsuit. Yes, he followed this message, but lawsuit my anticipation is that because as you see in Federal 9 payment 11 state lawsuit. Even 9 guys coming to our lawsuit. But I want to refer to. Yes. Very what NRC document next time not because NRC document was issued by officer in charge of some rehabilitation working. May I read maintenance level? Okay, on this is that nothing inquiry officer's report or this would be merely institutional in nature and notice which cannot be said to have certain finality on the status of huh? Student forwarded the matter concerned. Of two of the foreigners tribunal order 1964 provides that the central government may by order refer the question as to whether the person is called not a foreigner within the meaning of foreigner a candidate for the case tribunal to be constituted for the purpose of for his opinion. It is suggested the central government by an appropriate notification has delegated its power under clause 2 of the foreigner tribunal order 1964 into the superintendent of police border of the respective district to make any order referring to the question on the citizenship of a person to a tribunal constituted for the purpose of for its opinion. The provisions of clause 2 of the foreigner tribunal order 1964 makes it explicit that it is the district border who would be the authority to make the decision based upon the report of the inquiry or any further material that may be available as to whether the person concerned is required to be referred to a tribunal for its opinion as to whether he is a foreigner or not. Regime of provision of clause 2 of the Foreigner Tribunal Order 1964 as indicated above also leads to a conclusion that the report of the investigating authority that may have been submitted as to whether the suspected person is a foreigner or not would be merely indicative in nature and cannot be said to have attained finality on the status of the suspected person as to whether he is a foreigner. From such point of view, we are unable to accept the submission of Mr. R. Ali Lawrence for the petitioner that as because the inquiring authority in the instant case has given a report that the petitioner is not a foreigner, therefore superintendent of police border did not have any jurisdiction to make a reference to the tribunal for an opinion as to whether he is a citizen or not, and accordingly the reference itself made is a defective reference which is required to be returned back.
Yes, sir. Okay. There is no reference against the Jews.
Forwarding the inquiry that's the no, that's not the wrong logic. I have something logic. But I'm going to be
You see this Aziz Mia was a writ petition where the call was to decide as to whether the reference can be returned. Correct. That there is not an authority on the point as to whether how the reference was made, because this does not disclose the note of the inquiry officer and the note of the superintendent of police. So what was the EO report and how did the SP deal with it? We are not aware of from this order. Therefore, this was a reference only for the purpose of the plea of the petitioner, Aziz Mia, that the inquiry should be returned. So therefore, the court had no business to look into those aspects. And therefore, the court had no occasion to refer to Order 3 of the Furnished Tribunal's order. What does 3 say? Suspect is to be given a ground. How is that complied with in this case? So therefore, whether there is a reference or not is an issue under Order 2. And therefore, this court says once a reference is made, you go to the tribunal. This cannot be quashed or set aside. So that was the case before the court in Aziz Mia. Aziz Mia was never called upon to look into a report where the Superintendent of Police agrees with the opinion of the inquiry officer. Okay, we'll pass orders in the chambers. Okay. The submissions of both sides are concluded. Judgment is over.
All right.
For hearing item 8.
None appears on call for the petition. How all the respondents are represented. It is made clear that if the petitioner remains absent or unrepresented on the next date of listing, adverse orders could follow. Next list again on. Give a date, fixed date. Hearing. It is hearing.
Time being item 4.
I believe in that. But the impinging opinion at page 49, my lord. The petitioner, my lord, relied upon 1951 NRC, my lord.
Where is your written statement?
Written statement at page, my lord. My lord, I could not annex the, my lord, written statement. That is in the record now. And also, my lord, the cross part, that also could not annex fine.
My lord,
You don't have a case. In the written statement, you don't introduce your brother. Your brother comes and deposes the DW2,
yes, my lord.
and then there are only 5 exhibited documents.
Yes.
One is an NRC,
NRC,
inadmissible.
1990,
Then exhibit B is
97 totally.
97. Then the EPIC, which is not an admissible document.
Yes, ma'am.
Then
Total list of
The-
2010,
Gram Panchayat certificate,
yes.
that also goes because of the, that and the Gauhati certificate. They
Yes.
both go because of use of
Governor was
emblem,
not examined.
emblem. And they were not examined.
Only, my lord, the linkage, yes, linkage certificate, my lord, the Panchayat certificate,
That also
But
goes,
that was not, my lord.
there is a use of state emblem.
and DW2 is the elder brother,
Hmm?
and DW2.
DW2 is a stranger. His name is not reflected in the written statement. And he does not prove his own identity. He exhibits 1997 voter list. That's not sufficient to connect. Please go. Yes, please. এটা সব যিনি খালি ফাদার এটা আছে দিনা বুড়ি বেবা আচ্ছা আজীবন দিদি AGIMAN আজীবন দিদি নানান কিছু চলে কিন্তু BBC ওটা exhibit itu Azirun Nasa সাথে আজীবন এটা আজিরুন আজিরুন 75 it is also 25 Your address is at which, your house is at which village?
My lord, Dharampur, she got married, my lord, in the village Dharampur. But his father's original place was, my lord, Mathar Sor, South Salmara, district Dhuburi. And she was married to Dharampur, under Gorpeta district.
Do you have a copy of that NRC with you?
NRC, my lord, this is, my lord, at the time the district was Gwalpara, my lord. That is
Whatever be, you have a copy of that?
NRC copy, my lord.
Exhibit 1,
Yes,
Exhibit A, you have a copy?
yes, my lord.
Look at the entry number 3.
Entry number 3, my lord, Jinnat Ali, he is the father.
No, not 1. Entry number 3 is
my lord,
Ajimon Bibi.
Ajimon Bibi.
Ajiman.
Ajiman, yes.
Correct.
Bibi.
Now come to page 54 of your writ petition. Oh, sir, no, not 54. Exhibit F, wherever it is.
Exhibit F,
F.
is
1997. You have got a copy? Exhibit F?
F, my lord. F is not available, my lord.
F is not available.
Up to, my lord, exhibit E, I have.
Mhm. Sign করেছে, sign করেছে। হুম। It is certificate copy, what is it? Because GS. FIG. And exhibit F, the serial number 3 is Ajirun, Ajirun.
Ajirun.
Ajirun, and there's no description of how Ajimon becomes Ajirun. And that exhibit F is of 1997 voter list of village Abadi Gaon. We don't find anything regarding shifting. Certified. Gauhati Gaon. A2 was Kasim Mandal Gaon. A2 Hagol. Village. Janja. Exhibit E, there is a
Exhibit E is my.
tampering.
Yes. On-site certificate.
There is a tampering there. Gambura certificate. everything goes, there's no link, no proof.
Gaura Sati.
This is a case of no proof and no link.
Page 37. Yes, I have seen that. But no explanation. Yes, in WS, my lord, no explanation made. Very poor WS.
Yes.
And the list of 2014, 14.
There is no positive statement also. There is no positive statement in respect of his parents also. Yes, Lord. Yes. Yes, nothing. Yes. Only Gauhati certificate. The office of the secretary, Gauhati of district Bongaigaon, issued a linkage certificate showing linkage with her father Jinnat Ali and husband Suleiman Ali.
Do you want to say anything else? Make your submissions.
My lord, only the facts remain, my lord, the DW2. He is the elder brother of the petitioner, my lord. And my lord, his name has been recorded with his father, the parents of the petitioner, my lord. And other, my lord, linkage as linkage certificate, concise and Gaura certificate, my lord. The issuing of authority, my lord, was not examined. But these are exhibited documents, my lord. And the concise certificate is specifically mentioned that the Jinnat Ali is her father and she got married to Solman. And my lord, regarding my lord NRC of 1951, my lord, it is the name of Azimon Bibi, my lord. And her name in some documents has been recorded as Azi Ron Nesa Aziron Bibi. But in the WS, there is no explanation. That is, my lord, admitted that. But Azimon Bibi is the mother of the petitioner. That is reflected in the concise certificate. And apart from this, my lord, the evidence of DW, written evidence of DW 1 and 2.
Panchayat
These are
certificate,
missing.
Panchayat certificate was issued on
Panchayat certificate. Issued on, my lord, 33/06/2015.
If the name was wrong, you could have got it corrected. You did not do so.
Shukuron, my lord, Shukuron Nesa.
You understand, but you did not have your name corrected.
Yes, my Shukuron and my lord, Shukuran, Shukuron and Shukuron. Shukiron and Shukuron. That is perhaps not in the WS, my lord, but I made explanation in my petition. That Shukiron and Shukuron is the same in one person.
That you get a certificate. Then you can't say that certificate is wrong. You got the certificate.
My lord, Panchayat certificate.
You see, you went there and got the certificate.
Yes, my lord.
That certificate is not automatic. You request them and they give it to you. You can't take that tea that the Super and Nasa, the name was wrongly spelled.
My lord, maybe some documents where her name has been recorded as Sukiron. Because, my lord, this certificate is issued based on the evidence placed before me. Meaning by, my lord, some documents has been, my lord, produced.
That's not believable. Your writ petition page 37 doesn't say that he examined any document. And if you already have a marriage certificate, why would you get a link certificate? You would have produced the original marriage certificate. So that is not there. So what document was
The marriage certificate
shown?
was not, my lord.
Therefore, what document he like to have your date of marriage on 2/4/1994?
94.
What document?
Wrongly or rightly, my lord, inserted her name in Panchayat certificate, Sukiron or Sukuron. That explanation has been made in the, my lord, evidence in chief of the W1. At page 39, my lord, thereafter.
Regarding Panchayat certificate, Lordship, it was already settled, Lordship, 2018 347, Lordship.
We will come to it. Let Mr. Amit complete.
Other part, only, my lord, the name of DW2 is not explained in the WS. And he specifically stated that the petitioner is her younger sister. More specifically, my lord, in the reference, my lord, the petitioner's name is Sukuron Nessa, daughter of my lord late Jinnat Ali. Father's name is reflected in the reference. Although my lord, case is not properly projected, my lord, but in their documents it is mentioned. Father's name is mentioned.
Okay. Yes, Mr. Sharma.
Lordship has already pointed out, Lordship, only thing I want to say, Lordship, a variance between pleadings and proof is not permissible, Lordship. It is capital law, Lordship, regarding that Momin Ali's case. I want to refer para 12 and 13, Lordship.
Momin Ali.
Yes, Lordship, 2017 to GLT 1076.
Please give again.
2017 to GLT 1076. Para 12, 13. 17 also important, Lordship, although Proceedi said that his name reflected in the reflected along with his projected father here, but all it were never exhibited before the tribunal, Lordship. Para 13, 12, 13 and 17, Lordship. I am relying. This written statement of the petitioner was wholly inadequate and did not disclose any material facts as mentioned. As noticed above, it was the allegation of the state that petitioner was a foreigner. Therefore, as per mandate of Section 9 of the Foreigners Act 1946, it was the bounden duty of the petitioner to have disclosed all material facts, which were specifically within his knowledge in the written statement, but did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding the name of his mother and identity of his grandparents, both paternal and maternal. He did not mention anything about his brothers and sisters or about his marital status. On the basis of such written statement, it cannot be said that petitioner had stated anything substantial to show that he was not a foreigner but a citizen of India. It is a settled proposition of law that where a party fails to set up a case in his pleadings, he would be debarred from adducing evidence in his support at the stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. Then para 17, Lordship, reverting back to the written statement, it has already been noticed that there was not a whisper by the petitioner that he had a brother or sisters, not to speak of disclosing their names and other particulars. Therefore, the sudden appearance of Umar Ali in the witness box as brother of the petitioner has to be looked with suspicion, and this suspicion is further fortified by the fact that in the 1997 voter list, name of Umar Ali did not appear along with the petitioner. That appeared in Exhibit 6, land document so. So, Lordship, here neither in WS nor in evidence, Lordship, she never disclosed in respect of her brother's names, Lordship, and apart from that, parents' name also not. So, Lordship, even Lordship, his parents' names were not disclosed in the WS, Lordship. So, another important aspect, Lordship, my learned friend, makes submission in respect of conscience certificate. Same thing has been quoted, my lord, in this case, Lordship, reported in 2018 3 GLT 347. 2018 3 GLT 347 and connected WBC number is 7756 of 2016. Khudeja Khatun, Khudeja, Khudeja Khatun, Khatton. Okay. Para 15, 15.1. Lordship regarding Panchayat certificate, Lordship, what my learned friend has submitted that, and that certificate was issued on the basis of evidence placed before the secretary, Lordship. On that point, Lordship, it was discussed. Exhibit D is a certificate, para 15. Exhibit D is a certificate dated 15/6/2015 issued by the secretary in Goriabari Gaon Panchayat certifying that Khudeja Khatun was the daughter of Jonabali. At the top of the certificate, Government of Assam was prominently printed. It was also mentioned that mentioned in the certificate that the same was issued on the basis of the evidence placed before the secretary. Firstly, this document does not appear to be a genuine document inasmuch as a Gaon Panchayat is not a department of Government of Assam. Therefore, Gaon Panchayat is not authorized to use letterhead with Government of Assam printed therein. Secondly, the secretary of the Gaon Panchayat did not testify before the tribunal along with the evidence on the basis of which exhibit D certificate was issued to prove the certificate as well as the contents thereof. Therefore, this certificate was not proved. Thirdly, Supreme Court has clarified in Rupajan Begum versus Union of India reported in 2018 1 SCC 579 that such a certificate of the Gaon Panchayat secretary is by no means proof of citizenship. Such a certificate has to be verified at two stages. At the first stage, authenticity of the certificate itself is required to be verified to find out as to whether it is genuine or not. The second stage of verification relates to verification of the contents, and there is nothing on record to show that Exhibit D had undergone any such verification exercise. Therefore, Exhibit D cannot be accepted as a valid piece of evidence. So, Lordship, if brother's evidence goes, exhibit and certificate of Gaon Panchayat as well as Gavra certificate goes, then nothing will remain, Lordship. This is my humble submission, Lordship.
Lord, in the WS, my lord, the explanation regarding the parents is there. My learned friend is saying that in WS, there is no explanation regarding the parents.
Regarding?
Parents of the petitioner. But the parents' name are there in the. And
You will find written statement at page 18 of that brief,
yes,
page 18 to 31.
it came here for
3 pages are the documents,
Yes.
the WS and others are documents.
My lord, in the very outset of the WS, my lord, the written statement submitted by the second party, Shukuran Nessa, daughter of late Jinnat Ali, and wife of Suleiman Ali. Father's name is there, my lord. And my lord, the Panchayat certificate.
Not only there, you will find it in the last page also. We told you, that's why we have sent this. We are conscious of the fact that the father's name is given.
My lord, in affidavit.
Showing that third page of the written statement, it will be, I think, that page 21.
Yes, 21. Daughter of Jinnat Ali, yes, my lord. Yes, my father's name is there. And my lord, regarding Gaon Panchayat certificate, my lord, that is countersigned by the block
Father's name doesn't
development
help you. That is not what he has submitted.
Yes,
Your parents' name is not there. You must have a mother to be born. You don't give that name. Your name of your siblings are not there.
yes, my lord.
Then year of your birth is not given. There is no data from which we can identify you. We can gather your age or we can identify you. Your statement, look at your cross-examination. You say that you're not stated why your mother's name is not there in the electoral roll. Look at Exhibit F. In Exhibit F, the name of your mother is there, but you don't disclose the discrepancy.
But the cross of DW1, my lord, may I read, my lord?
Have you seen the cross of DW2?
Two, my lord. Yes, my lord. Two.
What is the age of his mother in the cross-examination? He says 100 years. So therefore, the age difference between the mother and the son would be 60 years.
No, the siblings are not disclosed, my lord. Maybe, my lord.
We
here
understand.
the
We are
brother-
not asking you anything else. We are asking you from that cross.
Yes.
His age is 40. Or rather, the age of the petitioner is at that point of time 40. Mother is 100. So that will make an age difference of 60 years. You don't give the date of death of your father. We don't even know. Your name of your father appeared in which electoral roll? Your father, you've given a statement somewhere that your father was, oh no, you don't give a statement. When was the last voter list of your father? That is 1997.
1997.
And you know the difficulty? The difficulty is arithmetic. 2016, your mother is 100 years, correct? In page 18 of your writ petition, the age of your father in 1997 is 35 years. That means your mother would be 81 at that time and your father would be 35.
Age difference is there.
No, we don't know. You see, it's not your case that there is an age deficiency. We are asking you now. You don't give an explanation. it would be a consistent discrepancy, which is impermissible. You come to page 21. Here your age of your father is 47 in 2010. And 2010, your mother would be about
Yes.
92 years. If your brother is to be believed. There can't be a consistent mistake of the same nature. Now come to page 23. Although this is not exhibited in 2011, age of your father is 49. Your mother would be again 92, 93. 50 years age difference, 40 years age difference for the birth of a child. So 60 years age difference in birth of a child. It becomes more inconsistent.
Quite unnecessary.
In this repetition, your age is 43.
Yes.
That means you were born in 1975.
Nineteen 75, and her name should be enlisted in total list of 1993. If
1997, what is the age then?
1997, age was 25.
25. So this being 3 years of inconsistency in the age.
Yes. As per my lord, if her date of birth is 1995, then she will attain her majority in the year 1992.
We are not on that. We are just comparing the age. 1997, you were 25.
25.
That means your birth year is 1972. And according to the repetition, you are born in 2018, you are 43 years. It brings your age, year of birth in 1975. Sorry, we don't find anything. Inconsistency has to be proved. Every case we don't reject that inconsistency. Heard Mr. S. A. Ahmed, learned counsel for the petitioner. Also heard so from the respondent. Next. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the opinion dated page 49, passed by so and so and so and so. The petitioner was declared to be a foreigner of post 25 to 1971 street. Next one. Just pass me the record. It is technically here. On service of notice of the proceedings, the petitioner appeared before the learned tribunal, and on 1/6/2016, she had filed her written statement amongst others, stating that there was no cause of action for the proceedings. The case cannot be tried in the present form. And the police report was vague and false because at the time of inquiry, no police officer had asked the petitioner regarding her entry into India. The petitioner claimed to be born at village Abadi, Abadi, PO Chakihali, Chakihali, PS Manipur in the district of Bongaigaon, and she grew up there. And she got married to Saleman Ali, Saleman, Saleman Ali, of village Dharmapur, Dharmapur, Moza Rupsi, Rupsi, PS Sarvog in the district of Borpeta, and he has been living there. Petitioner has stated that her actual and correct name is Sukuron, Sukuron, Nasa, which has been written in all relevant documents, but in the notice of this case, her name was written as Sukuran, Sukran, Sukuran Nasa, Nessa, and therefore both are the names of one person. He stated that the name of her father appeared in the NRC of 1951, and her own name appeared in the voters list of 1997 at village Dharmapur. Look at 1997, 2010, and 2010 so. The petitioner has an EPIC, EPIC, issued by the Election Commission of India. She also has the certificate, link certificate, issued by the Secretary, Jhawabari, Jhawabari, Gaon Panchayat. And from the Gangura of the village Dharampur. Stop. In support of her defense, the petitioner had examined herself as DW1, and he has also examined one Inas, INNAS, Inas Ali, her projected brother as DW2. Next, in her evidence on affidavit, the petitioner had reiterated the statements made in the written statement. And has exhibited the following documents. So one of NRC of certified copy of NRC of 1951 within bracket Exhibit A, certified copy of voters list of 1997 within bracket Exhibit B, EPIC within bracket Exhibit C, link certificate issued, link certificate of the Panchayat Secretary within bracket Exhibit D. Next, Gauhati certificate within bracket Exhibit E. So in a cross-examination, the petitioner had admitted that her first, she had cast her vote for the first time in the year 1997. And she has been voting till date. She could not say when her father had expired, and she could not say why the name of her father of her mother did not appear in any voting list. So she has stated that the age of her mother was approximately approximately 100 years. She had denied that she had given false evidence. Next, Inas Ali, who was examined as DW2, had also had stated that the petitioner was her younger sister, aged about 42 years, and she was born at village Abadi, ABADI, and she reiterated the statement made by the petitioner in her evidence on affidavit. He had exhibited the following two documents. One is certified copy of voter list of 1997 within bracket Exhibit F, and his epic within bracket Exhibit G. In his cross-examination, the DW2 had stated that he stays as Avadi Gaon, but his birth was at Badar
Mother.
What is the name of this village?
But the original, the parents' village. Mathar Sormal. Matherchar.
No,
Yes,
it's not
South
Mathar.
Salvar district.
This is not Mathar. Mother Sarutono hai.
Mother soul.
Mother Saru. Mother Saru. MADAR Mother Sar village. Mother Sar. Mother Sar. MADAR Mother Sar.
Mother, yes, Mother, Sar.
Village. No, because we are reading it from your English translation and then comparing, because in this Assamese,
Yes.
we just can't say what has been written. 53. Just see. Page 53, I put it in the upfile.
In NRC Malot, it is mentioned in Assamese, Mother, Sar.
Just we are giving it, we're not very sure. Mo we can't read, but we can read bo.
Page 53, Lordship.
53. More Janmo. I stayed so and so village. My birth was in this village.
Mudarsor গাঁৱত গৈছিল। মাদাৰচৰ গাঁও। মাদাৰচৰ।
Mother Sor. Not SIR then. It will be Chor. CHAR. Mother Sor. It's a separate word here.
Yes, Lordship. Madarsor.
But then you see, we find it. But see page 17 of the repetition. Is one word.
Here, my lord,
মাদারসর
Madar-
কাসেম মন্ডলের গ্রাম। মাদারসর কাসেম মন্ডলের গ্রাম।
No, but that is one word. In this
It is joint, Lordship. Madarsor.
joint Mother Sir. Okay. Mother Sir. Please send it back. But Mo is very invisible. That
Yes.
it looks like Bo.
Yes.
so.
Madi. Madi word pisote. Word no hai.
পিছত মই
Madi ki.
ডাঙৰ হোৱাৰ পিছত নেকি?
Dhagar pisote.
ডাঙৰ হোৱাৰ পিছত
Avadi Gaon. He came to Avadi Gaon. Madi. Madi.
ভাঙাৰ পিছত নেকি?
বিবাহৰ পিছত হ'ব, জন্মৰ পিছত হ'ব, কিবা এটা হ'ব। জন্মটো নহয়।
জমি
জমি ভাড়াৰ পিছত।
জমিটো নহয়। আকৌ সুধিব লাগিব ছাৰ। আমি ডাঙৰ নহয় ছাৰ, ডাঙৰ নহয়।
Just read this. You are finding it very difficult. 53. You are stuck in the next line.
মোৰ নাম ইন্নাস আলী। মোৰ পিতাৰ নাম মৃত জিন্নাত আলী। মোৰ ককাৰ নাম মৃত চহৰ শেখ। মই আবাদী গাঁৱত থাকো। মোৰ জন্ম মদাৰচৰ গাঁৱত হৈছিল। নদী ভঙাৰ পিছত মই
Nodi bhayar episode. Okay.
নদী ভঙাৰ পিছত
After
মই
river
আবাদী
erosion,
গাঁৱত আহো।
just after river erosion, I shifted to, he shifted to
আবাদী
Avadi village. Avadi Gaon. Yes, then
মই প্ৰথম ভোট কেতিয়া দিছো মোৰ মনত নাই।
he does not remember when he voted for the first time.
বৰ্তমান মই ভোট দি আছো। মোৰ মা দেউতাৰ নাম 1965 চনৰ
He is casting his vote till date. the name of his mother and
Aro-
father appeared in the voters list of 1966,
65,
and 97.
65.
yes,
Okay,
1966/65 আৰু 1970 ভোটাৰ লিষ্টত নাম নাই।
So, however, their names do not appear in the voters list of 1970.
66, 65 and 70. মই 1951 চনৰ NRC এক্সিবিট এ দাখিল দিছো।
So, he had submitted the NRC of
51
1951.
এক্সিবিট এ। মোৰ খুৰা ভাই নাই।
No, he gave that, he had filed that document. So that's not an exhibited document.
61.
Here
that
he
is
has
exhibited
written.
document.
No, but look at the document file. It is only, I think, 1997 voter list in the EPIC. So that statement would be false.
Non-liability. 1965, 66,
No,
their names are
no
not.
name is there. Parents' name is not there.
এক্সিবিট এ it is exhibited document lordship.
1966 and 65, parents' name is not there.
Not there.
He is taken, yes.
Yes, not there.
Okay, not there. It's an exhibited document.
NRC is a exhibited document lordship. This is
Exhibit number?
8.
A,
No, A is not the issue.
66.
A was not filed by him. A was filed by the proceeding.
petitioner.
Then lordship, I think statement is false.
Statement is wrong.
Yes.
Okay.
No, my lord.
It is stated that
Not A.
although the DW2, in his cross-examination had stated that he had filed, he had submitted a copy of NRC of 1951, but the same is not found to be borne by record. As the document marked as Exhibit A, which is the NRC of 1951, was exhibited by the petitioner as DW1.
Yes.
This will be in bracket, first bracket. Yes, then,
মোৰ খুৰা ভাই নাই, চুকুৰুন নেচা, মোৰ
okay.
নিজৰ ভনী হয়,
Petition.
মোৰ মাৰ নাম আজিৰণ নেচা,
He does not have any,
খুৰা ভাই, uncle,
uncle
brother.
and brothers.
খুৰা আৰু ভাই নেকি?
Yes, খুৰা কমা ভাই নাই।
Uncle and brother.
And then he denies that he has given false evidence.
চুকুৰুন নেচা মোৰ নিজৰ ভনী হয়, মোৰ মাৰ নাম আজিৰণ নেচা।
Okay, he has stated that the petitioner is his own sister. And
Time.
the name of his mother is
Time. No.
Ajiron Nessa. Ajiron.
Yes,
No, my lord.
আজিৰণ নেচা।
Ajiron Mesa is the mother.
মাদাৰ, মোৰ মাৰ নাম আজিৰণ নেচা, তাই মোৰ সৰু ভনী।
No, Sukuron Mesa, Sukuron Mesa. Mother is not one. Sukuron Mesa, more major boni hoy.
Have you written that?
Mother's name is not there, my lord. More Mar Nam Ajiron Mesa. Later
that's right.
on, my mother name is there. And time more Horu Boni hoy. She is my younger.
You have made that. That's all?
Yes, after that suggestion lordship, এইটো সত্য নহয় যে মই ইয়াত মিছা সাক্ষী দিছো।
So he has denied that he has given false evidence.
After that cross, মই আজি 1997 চনৰ ভোটাৰ তালিকা জমা দিছো আৰু ভোটাৰ আইডেন্টিটি কাৰ্ড জমা দিছো। মই যেতিয়া গম পালো যে মোৰ দেউতাৰ নাম ভুল হৈ আহে, কিন্তু মই কোনো ধৰণৰ দৰখাস্ত
অফিচত দিয়া নাই মোৰ ককাৰ নাম শুদ্ধ কৰাৰ বাবে কাৰণে ককা দেউতাৰ নাম শুদ্ধ কৰাৰ কাৰণে এইটো সত্য নহয় যে ইয়াত মই মিথ্যা সাক্ষী দিব আহিছো that matter.
Yes, statement will not apply for correction of the name of his father and grandfather in the voters list. Father and grandfather in the voters list. Denied in the last of them. He denied that he is given false evidence. Next, the learned tribunal, upon preceding the pleadings in the statement and the evidence of the evidence tendered by the DW1 and DW2, discarded the NRC record of 1951 within bracket Exhibit A, as it was not, as there was no authenticity of the said document. Therefore, the other documents exhibited by the petitioner were not found to satisfy the onus of proof that the petitioner was a citizen of India, not a foreigner. Accordingly, the petitioner was declared to be a foreigner post 25 to 1971 3. Next. The learned counsel for the petitioner had submitted that the learned tribunal had decided the matter without considering the relevant documents and evidence submitted by the petitioner, and arbitrarily held that the petitioner had failed to prove a linkage with the parents and the parents. First off, it has been submitted that the DW2 had given oral evidence with regard to the petitioner being her sister, and therefore his evidence could not have been discarded by the learned tribunal. Similarly, it was submitted that the petitioner had exhibited the certificate issued by the secretary of the Jhawbari, JHAWBARI, Gaon Panchayat, and the Gambura certificate of village Abadi, ABADI, which was a linked certificate and could not have been discarded by the said learned tribunal. So, Accordingly, it is print that the impugn opinion be interfered with, and the petitioner be declared to be not a foreigner. Have we failed to record any of your submissions? Have you recorded your submissions correctly? Okay. Next paragraph. The contract of the learned standing counsel for the FT and border matters has made his submissions in support of the impugned opinion. In support of his submissions that there cannot be variance between the pleadings and the evidence. However, he submitted that the same is held to be impermissible in the decision of this court in the case of Momin Ali, M-O-M-I-N, Ali versus Union of India, 2017, within bracket 2, GLT 1076. In support of the submissions that the Panchayat certificate was inadmissible as it was issued on the basis of evidence placed before the Secretary of the Town Panchayat, the reliance has been placed on the case of Khudeja, Khudeja, Khatun, KHATWM versus Union of India, 2018, within bracket 3, bracket 4, GLT 347. Accordingly, it is submitted that the Gambura and the Gauhati certificate do not have any evidentiary value. Next paragraph. Consider the submissions made at the bar and the submissions and cases handled at the bar, and also peruse the tribunal's records, which was called for. In this case, the petitioner relies on the NRC of 1951, within bracket Exhibit A, where the village of where the name of the village is Kasem, K-A-S-E-M, Kasem Mandalore, M-O-N-D-A-L-O-R, Mandalore Gaon. So there is no statement in the in her written statement regarding shifting of her parents from Kasem Mandalore Gaon to Abadi village, A-B-A-D-I. So this would be relevant because the secretary of the Jhabari Gaon Panchayat in exhibit in his certificate within bracket exhibit D, refer to the father and mother of the petitioner as a resident of Abadi, ABADI, Abadi village. Full stop. Moreover, the said panchayat certificate within bracket exhibit D, as well as the certificate of the Gambura within bracket exhibit E, do not have any evidentiary value because of unauthorized use of the state emblem of the lion pillar of Asoka. Full stop. The inadmissibility, in respect of inadmissibility of documents containing unauthorized use of the state emblem, comma, one may refer to the case of Sajeda, SAJEDA, Sajeda Khatun versus Union of India, comma, 2018, within bracket 4, bracket close GLT 696. This one. Next, insofar as the voter list of 2010 within bracket exhibit B is concerned, voter list, what does it prove? 2010 voter list.
2010 my lord voter list. Yes, 20 my lord in notification. That is the Sukurun Nessa petitioner and her
Name of the petitioner along with her husband's family.
yes,
Directs to the is projected to be the voter list of the petitioner along with her husband and family members of her husband. The same does not link the petitioner to her projected father, whose name purportedly is shown to appear in the NRC of 1951. Full stop. Same is with regard to the epic of the petitioner within bracket exhibit C, which is not a document which links the petitioner to a projected parents. Full stop. The projected brother of the petitioner, namely Inas Ali, INNAS, Inas Ali, had exhibited the voter list of 1997. within bracket exhibit F. How this power in paragraph 11 of the evidence on affidavit, comma, the DW2 has stated that his name appears in the voters list of 1997 under 34 number Abhayapuri ABHAYAPURI, North LAC, by serial number 505, comma, house number 11, comma, part number 35 of village 55 Abadi Gaon, ABADIGAON, of PS Manikpur in the district of Bongaigaon, Assam. Therefore, comma, comma, in his evidence on affidavit, comma, the DW2 does not disclose his relationship with the other three voters whose name appear in the said voters list. Thus, comma, even the DW2 has failed to show his link with the persons whose name appear in the NRC of 1951 within bracket exhibit A. And the said exhibit F fails to connect the petitioner with her projected parents. Full stop. Similarly, comma, the epic of the DW2 within bracket exhibit G, though reflects the name of his father as Jinat Ali, comma, but there is lack of evidence to show that the Jinat Ali, whose name appeared in the NRC of 1951 within bracket exhibit A, is the same Jinat Ali whose name appeared as father of the DW2 in the epic within bracket exhibit G. Next paragraph. In this case, the petitioner has failed to exhibit any document showing continuous stay of her parents in India after the name of the father of the petitioner appears in the NRC of 1951. Till the date, evidence was tendered by the DW1 and DW2 which is a requirement of section 6-A within bracket 3 within bracket B of the Citizenship Act, 1955. Therefore, the special provisions as to the citizenship of persons covered by the Assam Accord also do not come to the help of the petitioner to prove that parents had continued stay within the country within the scope of said section 6A within bracket 3 within bracket B of the Citizenship Act, 1955. Next, therefore, the petitioner has not been able to show anything from the records of the learned tribunal that she could link herself to her projected parents or her projected elder brother in any manner whatsoever. Next, although the court is conscious of the fact that some discrepancies in the name of the persons cannot be viewed in a very serious cannot be negatively viewed seriously against the proceeding, but in this case, the petitioner or the DW2 have miserably failed to even refer to the 4 entries which are made in the NRC and to link them with entries made in any other exhibited documents. So as stated here before, the record of NRC is not admissible in evidence, the reason being that the NRC of the exercise of the NRC of 1951 was under the Census Act, but notwithstanding the same, the village of which the said NRC Patel is of Kasim Mandalor Gaon. Full stop. On the perusal of the said Exhibit A, it appears that the name appearing in serial number 3 is inverted commas Ajimon, AJIMAN BV, whose inverted commas whose age is 25 years as per the NRC of 1951. It would mean that the said person was born in or around the year 1926, which is in contrast to the statement made by the petitioner in her cross-examination on on 5/10/2016, where even she says that the age of her mother was approximately 100 years, which would mean that the mother would have been born sometime in the year 1916, and therefore there was a mismatch of the projected age, the age of the projected mother. And moreover, her name in the voters list of 1990 exhibited voters list of 1997 within bracket exhibit F is Ajirun, Ajirun, Ajirun Nasa, aged 75 years. It should make the year of birth at 1922. Notwithstanding the fact that the said Ajirun Nasa is a voter of village Abadi Gaon, and there is no evidence, pleadings or evidence on by the petitioner regarding shifting of her mother to village, projected mother to village Abadi Gaon. Next paragraph. Therefore, the court does not find any conformity with the opinion expressed by the learned tribunal. Opinion dictates also by the tribunal. Next paragraph. Accordingly, the challenge made by view of this petition fails and the same is dismissed. Next paragraph. The opinion, the consequences of the said opinion shall follow. Next, the registry shall send back the tribunal's records along with a copy of this order to be made a part of record by the said learned tribunal. Next task.
Obliged.
We won't have time to take up any other matter. Although two or three of you are sitting. This next item is item 9. Let us see that. Item 9. Here, both records have come. Have you seen both the records? No. Two records were called for because I think there is some connection Who is Hakimuddin?
Hakimuddin is the brother of the petitioner.
Brother. He was declared not a foreigner.
Yes, my lord.
Okay, you have to go through this record. I have not been able to examine this today. You want the record?
Not
Or you'll see it on that day? But this needs some examination. I think the cell deed is common.
Yeah.
And voter list is common. Correct?
Yes.
I want to retain it.
You want to retain it, okay. You say both sides are represented. In terms of the orders passed earlier, comma, records of two separate proceedings, comma, which we call for as is received. Full stop. Next para, the of the Mr. G. Sharma, the next time counsel for the FT and border matters, praised for providing him with the with both the TCRs, was to enable him to examine and then address the court. Mr. Prayer is allowed. The court master shall hand over the records of FT case number 425 of 2016 and FT case number 426 of 2016, both disposed of by the Foreigners Tribunal number 11th, Borpeta, Sarvog. Just to enable him to peruse the same and to address the court. Next para list the matter for hearing on. Give a date after a week. We may not be able to take up other matters. Those will be rolled over.
Yes,